Hello, everybody. Not sure if this is working yet. Offline. It says I'm offline. Oh. Can you guys hear me or see me? Well, hello there. Can you guys hear me? Okay. Yes, yes, yes. Excellent. Great. All right. Camera is there. My other screen is here. Bear with me while I'm getting used to all this stuff. Thanks for coming, guys. All right. So let me start with some people have asked how they can donate and support my work. So as you can see, there's a little scrolly thing at the bottom of the screen, and my Twitter account for people who happen upon here that don't follow me on Twitter. There's my address and my website where you can donate one time or monthly reoccurring. So that's all I need to say about that. Excellent. Okay. So as we all know, or maybe some of you don't, I'll be discussing false allegations, wrongful convictions, and case law around sex crime criminal cases in Canada. And it so happens, based on all of my research that I've done on overturned convictions in Canada, the four most common reasons for overturned convictions: number 1, judicial error; number 2, police or prosecutorial misconduct; and number 4, ineffective defense counsel; and number 3, perjurious testimony by the alleged victim. So with that, I'd like to move on to a case. So the case that I'm going to talk about is R versus AB, and this closed in 2016 in Ontario courts. Now, it just so happens that a couple of years ago, I guess it was right after this appeal, I actually went to a debate that was held by it was held at the University of Toronto, and the debate was between Elaine Craig, who is a law professor at Dalhousie in Nova Scotia, if I recall correctly. You may have seen her name, you may have heard me mention her, or other people, Diana Davison, mention her. She's a feminist law professor, and she writes, she writes about legal cases, and she's usually talking about outrageous acquittals and things that she thinks, cases that should not have been acquitted. And anyway, so this debate was between Elaine Craig and a Toronto defense lawyer named Alison Craig. The two of them are not related at all. They have the same last name, but they're absolutely not related. And they're diametrically opposed in many of their views as well. So it was a really interesting debate. And when I was going through my database of cases that I have of overturned convictions, I recognized one that I believe she was discussing, that she talked about in this debate, and she misrepresented it. And by the way she was talking about the case when I was there at the debate, I could tell she was misrepresenting the facts of the case. But the overall meat of it was that the accused was trying to adduce evidence of Facebook messages that proved that she consented to having sex. And the messages included really crude language, such as, I don't know how to say it without being really crude, but, basically, you effed me in the arse and it felt really good, stuff like that. And, like it was explicit sexual acts that she was describing that they did together, and how much she loved it, how she wanted more, and how she couldn't wait for the next time. And in this debate, Elaine Craig was outraged by this particular case because the fact that this evidence was even allowed to be admitted into this case. And she basically said that defense lawyers need more education, and that any such evidence should be subject to an application hearing before the trial to admit such evidence. And it shouldn't matter anyway. This evidence has nothing to do with the actual claim. And what was the other thing that she said? That lawyers like that should basically be up for misconduct, and they should be disbarred. They should be punished. They need to be retrained, yada yada. This is pretty much what she was saying in this debate. And I made note of the case AB, and I can't find the notes that I have now, but I have a bit of a photographic memory, so I know that case is this case that I'm about to present to you, which I'm hoping you guys can see. And what I'm going to do right now is I'm going to copy and paste this into the chat. So if you guys want to follow along, but I'm hoping my screen is clear enough and you guys can see it. So, okay, let me get to the case. So of course, things are not always as represented. Things are often misrepresented by feminist legal scholars in particular, who are the ones who have influence. But anyway, all right. So this is the appeal after he was convicted at trial. So the appellant was tried by a jury on an indictment that contained 3 counts of sexual assault and a single count of uttering death threats. The counts of sexual assault were alleged to have occurred on various dates or during defined time periods over about 26 months. The complainant on each count was the appellant's former spouse. All right, so there's obviously a relationship there. The allegations related to conduct said to have occurred after the appellant and his former spouse had separated. The appellant was then living with his new partner, his now wife. The complainant described 3 discrete instances on which she had unwillingly had sex with the appellant. The complainant said that on each occasion, the sexual incident occurred without her consent. The appellant testified at trial. He admitted to having had sex with the complainant, but said that on each occasion, the conduct was consensual and mutually agreeable. So prior to the trial, the appellant was represented by counsel who indicated her intention to cross-examine the complainant. Okay, well, as long as you can hear me. So to cross-examine the complainant on a Facebook message that the complainant allegedly sent to the appellant's now wife. The message was allegedly sent about midpoint in the time frame of the sexual assault allegations contained in the indictment. It would not be unfair to say that the message recounted several incidents of sexual activity between the appellant and complainant and made it clear that the sexual activity was consensual on the complainant's part. At trial, the appellant was self-represented. The trial judge appointed counsel to cross-examine the complainant under the auspices of Section 486(3) of the Criminal Code. Counsel sought to question the complainant about the Facebook message, and the complainant asserted no recollection of having sent the message and expressed the disbelief that she had done so. Appointed counsel sought to proceed further to cross-examine the complainant on the contents of the message. The trial crown objected on the basis that no Section 276 application had been made. The trial judge agreed, ruled that no further cross-examination could take place, and directed the jury to disregard all the evidence about the message. Let me just backtrack. The Crown objected on the basis that no Section 276 application had been made. What that is, the 276, is what is very relevant in the Bill C-51 that was just passed and what I'll be discussing next. That is the section that governs admitting sexual history of the complainant into the trial as your evidence in your defense. So there's already rules. This piece of legislation has existed for a long time, for about 30 plus years. The rules have gotten tougher and more strict over the years. So the Crown in this particular case was objecting that because this message had sexual content related to the complainant, that an application should have been made. And since it hasn't been, this should be tossed out and should not be taken into account at all in the course of the trial. And the judge agreed in this case, in this trial, and told the jury, disregard it, you didn't hear it, do not let it affect your judgment when you're coming to your verdict. So he ended up being convicted. In this appeal, the next section jumps right to the conviction and his subsequent appeal. So the appellate counsel invited forensic analysis of the appellant's wife's computer in order to determine the authenticity of the source of the message. So with the assistance of counsel for the respondent, an expert located the message on the wife's Facebook account and determined that neither the date nor the content of the message had been manipulated. A further investigation determined that the message had been sent from an IP address associated with the complainant's brother. When interviewed about the results of the investigation, the complainant then acknowledged having sent the message. Okay, so you saw what happened here. So at trial, she was, oh, I wouldn't send such a thing. Oh my God, I would never say that. I did not. I do not recall ever sending such a message. But then the appellant had to finally, hire a private investigator or whatever to do a forensic investigation to determine that that Facebook message indeed was sent from her, by her account, by her. And when she was caught in her lie, she finally acknowledged having sent the message. So this appeal goes on to acknowledge the Facebook messages as fresh evidence. Now, you can only call it fresh evidence if it's never been admitted into trial, or if it wasn't available at the time of trial. Hold on a sec, I need a drink. It's just water, sparkling water. I'm fancy that way. All right. So the appellant seeks leave to introduce as fresh evidence on his appeal from conviction, 1, a copy of the Facebook message sent to the appellant's wife, and 2, the results of a forensic analysis of the computer and Facebook account of the appellant's wife who received the message, and then 3, the results of a search to determine to whom the Facebook account from which the message originated was associated, and the complainant's acknowledgement of having sent the message. So for the Crown, he conceded that the appellant has established the prerequisites to admissibility for the proposed fresh evidence. The appeal court agreed. In the appeal court's view, the proposed fresh evidence is relevant to a potentially decisive issue, the complainant's credibility on the issue of consent, which was, after all, the only controverted element of the offense at trial. In other words, it was the only thing to decide at trial, whether or not she consented, because they agreed that they had sex. Okay, so the message had impeachment value as a statement inconsistent with the complainant's claim of non-consent asserted at trial. And second, as the parties agree, the proposed evidence is reasonably capable of belief. Well, I would say more than that, since forensic evidence proved the shit out of it. Anyway, third, As Mr. Scrutton for the Crown acknowledges, the proposed fresh evidence could have reasonably affected the verdict of the jury had it been elicited at trial. Indeed, prior to trial, then counsel for the Crown had conceded that authentication of the message warranted termination of the proceedings in their entirety. So in conclusion, in this result, we would admit the fresh evidence, set aside the conviction, and order a new trial. In accordance with the joint request of counsel in this court, we direct that the order for a new trial be stayed. Awesome. That's the correct verdict. So, first of all, we never like to order a new trial because, well, in cases like this, why? But then the appeal court goes on to stay the new trial, which means no new trial. So we will not waste any further resources. The accused no longer needs to spend any more money on this nonsense. So here we have a clear case of a woman caught in a lie. She was hoping to get away with it. She was probably told somewhere along the line that such evidence, if she knew it existed, probably would not be able to be admitted into court without, you know, some kind of, well, there's roadblocks basically, and she just denied it. You know, she was probably gonna try and get away with, well, somebody else must have sent it, I didn't send it, or somebody made it up, it's photoshopped, right? But bottom line is she was caught in her lie. So this is proof. Women lie. And this is a classic case of the couple were married, then they got divorced, and while they were divorced, they still screwed. They still, you know, had sex with benefits, or friends with benefits type of relationship. He met somebody new, and he got serious with the new woman. Obviously, the ex-wife did not like that, even though she had her own boyfriend at the time, but whatever. She still didn't like the fact that her ex-husband was with another woman, and decided to harass his new girlfriend, who is now his wife, but harass her by revealing all of the sexual acts that she was doing with her ex-husband, this woman's now boyfriend. It's disgusting what this woman did. It's absolutely disgusting. So one of the questions you first would be asking is at the time that the police arrested him, did they not have access to these Facebook messages? Did he show them to the police? We don't know. That I can't look that far back into the transcripts. I don't have those transcripts. That's a question that we don't know. And so there's different scenarios. The scenario is A, he didn't think of showing these Facebook messages to the police at the time because, well, maybe he didn't have his phone on him. Because when the police arrest you, they literally abduct you off the street from your workplace, and you have no recourse. They strip you of everything, and they put you in a jail cell or an interrogation room, and you're charged. You're already charged. They've already written up the charge sheet before you've even been arrested. That's how the police in Ontario operate. So it's, you know, if that's the scenario that happened here, he didn't get forewarning that he was, you know, gonna be arrested. He didn't get a friendly call from the police, you know, ahead of time saying, you know, this, I have a complaint from a woman who says that she's your ex-wife and that you raped her. Yeah, so I just thought you should know. And, you know, what do you want to tell me about that? No. Cops don't do that. They do not do that. They just go straight, they turn it into a production. They turn it into an operations. They plan your surveillance, and they plan your arrest. So they surveil you to see the best scenario to arrest you. And of course you're innocent, so you're not committing any crimes. So they don't have any reasonable probable cause to arrest you. The only probable cause, they're not catching you in any act. The only probable cause that they could conceivably have is the fact that this woman made a complaint. That's it. That is what our police officers consider probable cause. That's the minimum requirement. And that's what happened to this dude. Now, the other scenario is possibly that he did have his phone with him in the interrogation room, which is highly unlikely, but it's possible that he told the cops, "There's no way. She's harassing my wife, my girlfriend, and she sent her some terrible messages, and you better ask her to see those messages." So the cops will be like, all right, we'll check that out, but in the meantime, we're going to pass your case on to the Crown anyway. So apparently that's what happened, because that's how it ended up in court. A Crown actually took this case. So judging just by this appeal verdict here, it sounds like the Facebook messages never made themselves known until the trial. But I seriously doubt that. I think it was just ignored and blocked. He had no opportunity up until the trial. I think that's the most likely scenario. So this. Hey, Black Knight Fool. Thanks for joining. All right, let's see. Oh, thanks, Lone Wolf Logic. That's awesome. I hope I can keep this up, because yeah, it's a lot of work. I mean, since my last live stream, which was a total utter failure, it was just terrible quality. I spent pretty much most of the week prepping for this one and trying to make things better, more, a little better, presentable for you guys. All right, so Theodore the Canadian. What exactly do they consider the best scenario? What do you mean exactly? What are you referring to? So I'll just let Theodore Canadian get a chance to elaborate on his question. You liked the last one, Lone Wolf Logic? Okay. Well, I guess the content was still decent, but the quality was crappy. So Theodore Canadian, the best scenario that police consider to arrest the person in. Oh, well, from what I know, their preferred scenario, if that's what you're asking, is to get you in your workplace, humiliate you. You're least likely to run, and it creates a terrible air of doubt and scrutiny, and it's all around a bad scene. I don't know why, but cops prefer to arrest you at your workplace. If that answers your question, let me know. Okay. All right, thanks. Okay. So now I thought this case would be the best one to discuss in the context of yeah, cops can definitely suck. If they're actually, stopping crime in progress, then we want them to do that. And we hope they're doing it properly, and we expect them to be trained to do that. But when they are, yes, aren't the police supposed to investigate reported crimes? Well, Canadian curmudgeon, I don't know. Have you not been following my content? Because, yeah, we expect them to investigate, but they're actually, they make their own rules. That's how it works. And they've been infiltrated by feminists and lawyers, because it's in the legal industry's interest for the cops to just, cast a wide net and, catch as many fish as they can to keep lawyers busy, especially with all of the law students constantly turning out of law schools. They need something, they need jobs, right? And they need justification. And yeah, we would expect them to investigate reported crime. The first thing we would expect them to investigate is whether or not a crime actually occurred, right? had my fun with Peel Regional during a messy separation. Oh yeah, Peel Regional. I find the suburb police agencies are the worst, and this is what lawyers have told me as well. Defense lawyers, experienced defense lawyers, even cops. Actually, I've actually talked to, not you know, because I wanted to, but just in situations where the opportunity was there. So I like to actually take the opportunity to educate them. Because you'd be surprised, some of these cops don't know the laws. They don't know what happens to these men when they end up in court. They're literally just acting as a net to catch the man for the system. That's it. And but yeah, so I think the police units that have the embedded sex crime units, it's the sex crime units that are causing all of the problems, because they're literally trained not to challenge a complainant. And I've seen this in transcripts, multiple transcripts. Join the chat. Don't do that. Join the chat. Anyway, okay. So, yeah, sorry. That was my partner. I told him not to disturb me, but he did anyway. I told him to join it in the other room, but for some reason he's unable to. Okay. So anyway, yeah, the police are under no obligation to investigate, and the sex crime units in particular are trained not to challenge the complainant, it's actually documented. I have these documents in my archives, and I've probably posted them at one time or another, and I can dig them up again later, but I'm going from my memory here. It's actually documented to not challenge a complainant who may appear to be lying with a polygraph test. That's pretty extreme, but still it's documented not to do that. Do not ask them about getting any kind of therapy, because as soon as that question or that conversation is brought up, then it becomes fodder for the defense attorney, and it opens it up to the defense attorney to take that lead and investigate the medical records. And the police are, these sex crime units actually have created in-house training and policies where they literally do not want to do anything that challenges the complainant's story. They just let the complainant tell their story. They record it. Tell me more. Okay. What happened next? Oh, you poor thing. Oh, yeah, I can understand why you would be so depressed and why you would need to take all of those pills. Yes, I can understand. Go on. So that's how it works. And they just want to do the paperwork, make the case, and send it off to the courts and let them deal with it. So let me see what else there is here. I'm going to go to your chats here. Metro has virtually zero respect for Peel Regional. Yeah, okay. It's good to know. Phil, I'm aware of 2 cases of this sort being discussed. In both cases, the man was arrested first and the investigation was only started after the arrest. That is common. That's pretty much the standard, which people have no clue. People assume that if you're arrested by the cops, it's because there was sufficient evidence to give the cops probable cause to arrest you. And the general public's idea of sufficient evidence is proof. There was some sort of proof. There had to have been some proof. Oh, arrested at the airport. Yeah, well, that's too bad. Yeah, feminist theory turned into law, absolutely, and it's embedded in our actual criminal codes now. Durham Regional. Yeah, how about York Regional? Anybody here experience York Regional? Same as Durham. Anyway. Okay, so now let's move on to Bill C-51. I'm eager to get to that. All right, Bill C-51. So you guys probably saw John the Other's video. Let me see, I have it here. Yeah. Proof of consent banned from court. Okay. So it might be a little extreme, but essentially that's kind of what's happening here. So let me go to what I posted in response to his video. All right. So in response to his video, I posted new law passed for Canada criminal sex assault cases. If defendant has proof of consent, such as video or email, they must apply to have it admitted as evidence, but can't do it if, for the reason the accuser is A, likely to have consented, or B, is less worthy of belief. So that begs the question, but I'm admitting evidence that she consented to me having sex with her. So, what other reason would I want to admit it for other than A, proving she's likely to have consented, or B, she's lying that she didn't consent? Okay, so this creates quite a catch-22. Now, let me show you the existing law, which has been in existence for many years, around admitting complainant evidence around evidence of the complainant's sexual activity, which is 276, which was integral part of that case that I explained earlier. So I'll read it to you. 276.1. Evidence of complainant's sexual activity. In proceedings in respect of an offense under sections 151, 152, 153, 155, or 159, 160 or 170, 171, 172, 173, 271, 272, or 273, which are all variants of sex crimes. Evidence that the complainant has engaged in sexual activity, whether with the accused or with any other person, is not admissible to support an inference that, by reason of the sexual nature of that activity, the complainant A is more likely to have consented to the sexual activity that forms the subject matter of the charge, or B is less worthy of belief. So this is the current law around admitting this type of evidence. Now, the background for the creation of this law in the first place, and the reason why it was admitted in the first place, was legislated in the first place, was because there was a case, one case. Of course, these things always revolve around one case, one particular unique scenario. And it is then applied to everything that follows subsequently. So the one case that this was based on was a case of a prostitute who claimed her John raped her. And during the course of that case, I don't know the details of it, but you know, the generality is that he tried to use the defense, but she's a prostitute. She paid me for sex. I mean, I paid for her for sex. That was the deal. There's no way I raped her. She's a prostitute. You can't rape a prostitute if you're paying her for sex. It's not rape. So that case, at one point somewhere in the 80s or 90s, I guess 70s or 80s, or somewhere around there in those decades, that case spawned this legislation. It created hysteria from the feminists, and the feminists did then what they did now to the current Bill C-51 version, and they basically demanded and lobbied and pestered and harassed and just, you know, gathered all the feminists they could, legal scholars and students and feminist lawyers, everybody. There were debates, live debates. Even Marie Henin was involved in these types of debates when this was first being legislated. And the general agreement was that indeed, you know, if you're a prostitute and you're John being accused of raping her, you can still rape her, and she can still be raped by a John. So we need to create legislation that, you know, makes it more difficult for a John to use that as a defense. So that's why this legislation exists in the first place. All right. So then the next piece that's in this new Bill C-51 is a section that is going to interpret the sexual activity to include any communication made for a sexual purpose or whose content is of a sexual nature. Now, imagine, in this day and age, a man videotapes his partner in bed giving consent. I, Jane Doe, agree to have sex with this beautiful man right now. And, you know, that's captured, right? Imagine if he does that, or there's an email conversation like in A and B, the case R versus AB, where the woman sent Facebook messages to the man's girlfriend telling her about their sexual escapades and how she enjoyed them. Those two things fall in the same category. They both include communication made for a sexual purpose or whose content is of a sexual nature. All right, so now any of this content is now subject to a application hearing, which must take place before the trial. So the connection to R versus AB is that the Facebook messages were presented during trial and surprised the complainant, right? So this word surprising the complainant with evidence was bandied about quite a lot in lawyer group discussions and debates around these new Bill C-51 provisions. The argument was, how can you surprise a complainant with content when she's the one who wrote it? Or it's her in the video talking clearly. How can you surprise a complainant with something? You can't, right? So the elephant in the room in a situation like this is that the complainant is obviously lying. She's lying. Or he can lie too. But nobody wants to acknowledge that when they're talking about this stuff in legal circles. Nobody will acknowledge the fact that women lie. Complainants, men and women, complainants lie. So back to Bill C-51, there's actually a lot more in the amendments here to the 276 provision that overall have made it a lot more difficult for a accused man in particular to defend himself if he has proof that either A, she's lying, B, she's not credible, C, she gave consent, or D, the crime never occurred. So these new Bill C-51 provisions, I was looking at this earlier today for 276, just specific to 276. It starts here. This is where it starts. I'm going to copy and paste this link as well. And just so you guys know, I'm going to go on with this. And then when I'm done talking, then we'll do, I'll get back to the chat and we'll do Q&A and stuff. It's kind of hard for me to pay attention to your chats and stay focused on presenting this stuff. Okay. So, here's the new, here are the new pieces that will be added to our criminal code and legislation, and to the procedures and protocols of sex crime cases in courtrooms, criminal courts. There's a lot new, there are more conditions for admissibility of such content. So, all right. The conditions for admissibility. In proceedings in respect of an offense referred to in subsection 1, which are all the sex crime offenses that I listed off all those numbers earlier, evidence shall not be adduced by or on behalf of the accused that the complainant has engaged in sexual activity other than the sexual activity that forms the subject matter of the charge, whether with the accused or with any other person, unless the judge, provincial court judge, or justice determines, in accordance with the procedures set out in sections 278-93 and 278-94, that the evidence, A, is not being adduced for the purpose of supporting an inference described in subsection 1. And those inferences are the twin myths, which I also listed earlier, which are A, the complainant was more likely to have consented, or B, the complainant is less worthy of belief. So that is the first condition of admissibility, which we already know. It's already been in place. So that's, I guess they just changed some of the wording just to make it very clear that as soon as any such evidence is ever attempted to be admitted during trial, no go. That's it. It cannot happen. End of story. Can't even try it. So paragraph 276 of the Act is replaced by the following. C is of specific instances of sexual activity, and D has significant probative value that is not substantially outweighed by the danger of prejudice to the proper administration of justice. Okay, so I guess those are the reasons where it can be admitted, where at least it would be applicable for a 276 hearing, which has to take place before the trial. And then let me go down here. Okay, so the other part of this legislation that many defense lawyers are not happy with, but Justice Jody Wilson-Raybould just wouldn't hear any of it, wouldn't budge on any of it. Record. Definition of a record. So 278 is like 276. So a 276 application is specific to sexual activity or sexual communications, and 278 are other records. Any other record, like a health record, well, it's listed here. So I'll just read on. So in this section, the definition of record is any form of record that contains personal information for which there is a reasonable expectation of privacy and includes medical, psychiatric, therapeutic counseling, education, employment, child welfare, adoption, and social service records, personal journals and diaries, and records containing personal information, the production or disclosure of which is protected by any other act of Parliament or a provincial legislature, but does not include records made by persons responsible for the investigation or prosecution of the offense. Okay. So a lot of times people need to access these records to prove that the complainant is lying about some aspect of their complaint. And this law already exists. It has, I think it came in around the same time as 276 to protect the complainant. But some new things are being added. When you want to adduce a 278 hearing, a new service of application and subpoena. Okay. So not only does the accused have to serve the application to the prosecutor for such a hearing, but they will also have to serve it to the person who is in possession of the record, the hospital, doctor, etc., the school, onto the complainant or the witness, and any other person to the knowledge of the accused the record relates to. So let me just encapsulate what this means here. This means not only does the accused person have to have a hearing and beg the judge to get these records, but he also has to serve a subpoena in conjunction with this application hearing to the institution that holds the record, or the person that holds the record, the witness or the complainant. So A, you're having to pay for the lawyer to prepare the 278 application. Now you're also having to pay for a subpoena process, and I guess that subpoena has to be successful in order for your entire records application to be successful. And we all know that subpoenas aren't always successful. Okay, so let me move on to the next part of this, is that all of this stuff has to be done at least 60 days before the trial, which means you have to be aware of all of this evidence. That's also not always the case. During trials, stuff comes up. The witness says something that triggers something to the accused, or the complainant says something that triggers something to the accused. Oh, I can disprove that. I know there's a document, or I know somebody has this record or whatever that can disprove that. So, you know, let's get that out on cross-examination. It's too late by then. So the problem I'm seeing with this particular legislation is it's not accounting for what happens in that scenario. I'm assuming it halts and adjourns the trial, and then everybody has to make dates when they're available just to have this new 278 hearing date, and you have to make sure that the subpoenas are successful before that hearing happens, that scheduled hearing. Imagine the delays, imagine the problems, imagine the resources that takes, imagine the frustrations. It's just another roadblock thrown up to the defense. So the part that really blows my mind about this is the subpoena, because I'm pretty sure that was never a requirement. This is a new thing, as far as I know. If I'm wrong about that, please correct me, but I'm pretty sure that that's new. So the 278 application asking the judge to get permission to have those records released, basically ordering that institution to release those records to the judge, that's been the standard protocol. But now they're adding this new thing where not only do you have to do that, but you also, the defense, the accused person, is responsible for subpoenaing that institution, that complainant, that witness, to produce those records. So that's disturbing. That's another piece of the puzzle that if it fails, if it doesn't work, then your whole defense can fall apart on you. And if you're innocent, which, you know, you probably are, if you know that all of the proof exists that A, this crime never occurred and she's lying or he's lying, you know, without any of the stuff being admitted to the trial, either the jury or the judge is just going to believe the complainant, and you're toast. That's terrible. So then it goes on about the requirements for admissibility, and what that means is it's up to the judge at this point. These are the requirements that the judge has to consider. And there's a pretty extensive list. The factors that the judge shall consider is pretty extensive. Now, some of these sound fair and like they would work in the favor of the accused person, but it doesn't always work out that way. These factors have existed for quite a while. I don't think anything here has changed. Maybe mildly, slightly. So factors that the judge considers when determining if that evidence, so like in the R versus AB case that I cited earlier, if those Facebook messages were presented to the judge, they have to determine A, take into account the interests of justice, including the right of the accused to make full answer in defense, society's interest in encouraging the reporting of sexual assault offenses. That's a roadblock right there. Society's interest in encouraging the obtaining of treatment by complainants of sexual offenses. That's another roadblock. Whether there is a reasonable prospect that the evidence will assist in arriving at a just determination in the case. That's sort of a neutral roadblock, because that's up to the judge, because only the judge is going to be seeing this evidence and ruling on its admissibility. Nobody else in the court will see it, even if the accused already has a copy of it. That's one of the provisions that they've added into this, is even if the accused already has a copy of this record that he's saying this proves I'm innocent, or this proves she's lying about a critical aspect of her complaint, he still has to go through an entire hearing and subpoena the institute or the complainant. Like if it's a page from her diary and he happens to have a photocopy of it, he still has to subpoena her to produce that original diary, or I guess to agree. I don't really know, but something like that, right? He still has to subpoena her to produce her diary. Even if he has it. Or if it's a medical record in relation to the kids in a family dispute, something like that. If you already have your own copy of those CAS records and interviews, for example, you no longer just have the luxury of having the judge decide if that should be admitted, but you also have to subpoena the CAS. I don't know how much that costs. I don't know what's involved, but all I know is that that's a new roadblock. That's a stumbling block that can take time, effort. It can fail. If the CAS is already working against you, maybe they're not, but the bureaucracy at the CAS office could potentially delay the subpoena, them to respond to the subpoena. And it could affect the whole hearing dates that you have set, and just protract the whole process into ridiculous absurdity. So anyway, more factors that the judge shall consider. Whether there is a reasonable prospect that the evidence will assist in arriving at a just determination in the case. The need to remove from the fact-finding process any discriminatory belief or bias. Okay, that's reasonable. The risk that the evidence may unduly arouse sentiments of prejudice, sympathy, or hostility in the jury. That could work against a defense, absolutely. The potential prejudice to the complainant's personal dignity and right of privacy. That definitely works against the defense. It makes yeah. Okay. The right of the complainant and of every individual to a personal security and to the full protection and benefit of the law, and any other factor that the judge, provincial court judge, or justice considers relevant. There you go. Or any other factor that the judge decides is relevant. So in these cases, I've seen them. Some of them are in Can Lee. I know of some personally. These 278 applications. The judge reads them themselves, and they make a decision based on their own reasoning whether it's going to be admitted. You don't know what their reasoning is. They might make a ruling on it and explain their reasoning. But if they've already got a bias in their head against you, and being the accused person, you probably already are biased. They're biased against you. No. You don't know what they're thinking when they're reading these documents. They have a whole host of factors that they can manipulate any way they want to either determine it's admissible or it's not admissible. Basically, they can just make the decision, nah, I want to see him get convicted. I want to convict this dude. Or, you know, it could be the opposite. I don't know. But my point here is that there's so many factors for the judge to consider. And they have their own discretion to come up with whatever reason they decide it is or isn't relevant. That's kind of scary for the accused person, for the defense. Like, you have no control over that. So let's see, what's the last little bits here? application for the hearing. The application may be made to the judge, provincial court judge, or justice by or on behalf of the accused for a hearing under Section 278-94 to determine whether evidence is admissible. Okay, so that's standard. So that's pretty much the end of that whole area. So as you can see, there's some new stuff there. The subpoenaing, I'm pretty sure that's new. And the fact that all records now, any record that the accused may already have in his possession, you know, I have this piece of paper right here proves that she's lying, or this piece of paper proves, you know, it's got her statements on it. This piece of paper proves that the crime didn't happen. She's lying about something. Oh, you can't admit that. You can't cross-examine her on that piece of paper. She's already got her own copy. She knows this piece exists. Well, subject to a 278 hearing, sir. Sorry. And you're going to have to subpoena her as well. Or, you know, what is this document? Is that a CAS record? Oh, you're going to have to subpoena them for the original copy. That's what this legislation is doing. All right. I am going to move over. All right. So, hi, Real Raven 2000. Good to see you. I don't know what you missed. I was just babbling on. Sean Doherty is asking, is the hearing with a different judge? Sean Doherty, the application hearing, I'm assuming you're talking about the 278s or the 276s? No. Usually, no. It's the same judge who's hearing your case. Does that answer your question? Black Knight Fool. And now judges are being trained by feminists how to treat such cases. Yeah, that's a good point you raise. Actually, yeah, there's legislation being proposed to, you know, roll out special training for judges on all of these new laws and existing laws. The Judge Robin Camp case is sort of the whole, you know, milestone or, you know, reason for that, if you will. You know how I feel about that case based on the video that I made there. The thing is that you can't expect every judge to always get everything right. You also can't expect crowns to understand exactly all of these protocols. And defense lawyers. Defense lawyers can't know exactly what the protocols are going to be. There will be mistakes being made. On all aspects, the judge, the crown, and the defense. Mistakes will be made, mistakes have been made, and will be made. The problem with that is that it's going to be at the detriment of the innocent accused person. Because if, let's say he was acquitted in a case that went fairly smoothly, and he was acquitted, but a judge did allow a piece of evidence that the Crown decides to pick out as related to sexual activity or communication related to a sexual activity or a record or something that he questioned her on in cross-examination that he had to actually subpoena her on and have an application hearing for her. The Crown will win their appeal. Conviction, acquittal will be replaced with a conviction. He will have to go through the entire process of being dragged back to jail, reprocessed by the police, recharged, another bail hearing, and all of the pre-trial motions. Everything starts all over again for that poor dude. The problem is we have so many freaking laws now, so many little pieces of legislation that are so like crucial to the case that one mistake can completely just and utterly destroy the accused person. But who benefits from it all? Everybody else but him. everybody else benefits. The lawyers, the court systems, the transcriptionists, the court clerks, the police officers, you know, everybody, the crown, everybody benefits, except for the innocent accused. So, yeah, judges will be trained, but it's not like they're going to be locked into rooms and forced to learn anything. You know. Looks like they want to jail all working class and middle class men by default. Yeah, what can I say? It seems to be what they're trying to do. It's really weird. I find there's a really common thread of men who run their own business or are contract workers and have their own successful business. Like men who work in trade industries and men who own large pieces of property and farm or something like that. I find that's a very common thread with in these cases that I read. And it's weird. It's like, you know, is this what's being is this their new way of transferring wealth to the less fortunate, which they consider to be women, because women apparently are weak and less fortunate and, you know, oppressed? I don't know. Lone Wolf Logic asks me, do you consider yourself an anti-feminist or an MRA? I don't really ever think of myself as an MRA. I mean, sure, men have all sorts of rights that are being trampled on. So do women, people in general. We, the civilians, the little people, we have, like, you know, we're taxed to death. We're surveilled to death. We're subject to kidnapping with no reason by the police and tossed into jail and into the criminal court system. So I believe all of us are subject to a lot of wrongs. But I do believe that too many rights are being given to women. But in a way, I don't know if I consider it a right to be treated as a helpless, infantile, you know, needy damsel in distress who needs a therapeutic court action in my favor so that I get money handed to me. I don't see that as a right. I see that as an insult, personally. And I wouldn't want a man to have that same right at all. I don't think there's any honor in that. As far as anti-feminist, yes, I would definitely say I'm anti-feminist. I never was until just a few years ago. I never even considered myself feminist. Maybe I had feminist qualities just by nature of being a Canadian. But nowadays, yes, I'm definitely anti-feminist, and who knows, I might go to jail for that one day. So Phil, in a nutshell, they say you can mount a full defense, but they throw so many roadblocks in your way. Yes. They do. It's... I mean, I can't even put it into words how I feel about how disgusting that is. How many, like, here's new legislation that just adds new roadblocks, you know, for the sake of women. Why? I like, just because a complainant makes a complaint doesn't mean they're telling the truth. Apparently the system doesn't care if they're telling the truth. That's the part that baffles me. It's not a justice system if you don't care about the truth. So, as far as I'm concerned, our justice system is not legitimate. My guess is most of these cases would be before judge only. Yes. Most of these cases are. And, Black Knight Fool, the demographic of women who push for such laws does not necessarily represent of the majority of women who would take advantage of such laws. Yes, I agree with that as well. I think it's a combination of the feminist ideology, the radical feminist ideology that's been operating in our system for the last 30 plus years. A combination of that and the legal industry, because all of these provisions and things, roadblocks, if you will, they benefit lawyers. They enrich lawyers, and they ramp up the art of their argument. They challenge them to perfect their arguments, change their arguments, and they give the judges arguments to entertain. And basically, appeal courts, all they're good for is who's made the best argument. That's pretty much all they're good for, because their purpose is stated not to re-argue the facts of the case. That is not the appeal court's purpose. Their appeal court's purpose is to have a flawed argument pointed out to them, and then debate and discuss amongst themselves whether or not that argument was valid or in error or in violation of some one of the thousands of pieces of legislation that we have. Combined with men's chivalry to protect women. Well, it's definitely it's in men's nature to protect women. But it's also in women's nature to want to protect our men too. So it goes both ways. We just do it differently. I think it's ingrained in us to want to protect each other as a people. You know, if somebody has an accident on the street, like shit, years ago, back in the day when I regularly rode a bike around Toronto, I got caught in the streetcar tracks once and went head first, flew off my bike. I was wearing a helmet, but nonetheless, my head I landed head first on the ground, my head wedged in between a parked car's tire and the road. And for an instant, I thought I broke my neck, or I was dead, or I was going to go unconscious. It was really weird, scary. And then I kind of moved around and looked around, and I could see these two pairs of legs. And they were little stocky legs with, you know, little nylon stockings that were like up to the knees and sort of rolled at the top edge there, rolled down. With in the feet there were these little like black leather walking shoes, and then I looked up to the top of the women, and it was these old Jewish ladies, and they're just like, oh, you know, are you okay? Can we help you? Oh my god, they were horrified. They witnessed the whole thing, and they were just standing there, and they helped me, you know, and I was like thankful for that, because I was really discombobulated after that. I was fine, but you know, it was scary, but they helped. You know, they couldn't do much. They're two little old ladies, but it was in their nature to want to put themselves in that situation and make sure I was okay. And I was very grateful for that. I'll never forget that. And it's just in our nature to want to protect. And now, if I saw the same thing happen to a man, which I actually have, I saw a guy wipe out on a bike right in front of me. It stunned him, but I just happened to be right there, and I was like, oh my God, are you okay? And, you know, helped him, and he was all discombobulated just like I was in my accident, and he was very thankful. I just stayed with him and like held on to him and kept him stable until he was okay, and he felt like he could, you know, move on and go to wherever it was he was going, and he was thankful. He said so. So it's in our nature to want to protect people and help people. If we're sitting in a courtroom and we're watching someone get railroaded, you just want to stand up and yell, you know, but, you know, you'll get thrown out of court. Some people do, but lawyers, if you're there with lawyers, the lawyers will warn you ahead of time. Do not get emotional. Do not make your emotions known. Do not say anything. Respect the court. That's it. So the justice system is what forces us into what's the word I'm looking for? Like, denying our emotion and not acting on it the way we naturally would want to. That's the justice system. that does that and proponents of the justice system who do that. And in Canada, we seem to have a culture of proponents for a justice system that is very unfair to people who are having a hard time one way or another. The woman appointed to train the judges is Elizabeth Sheehy of U of O. She is the one who wrote that book that women should be allowed to kill partners who abuse them. Yeah, I know. Yeah, it's becoming more of a popular view. I stumbled across some TV show, I think, one day when I was at home during the day, and I was just doing something around, and I just wanted some background noise, and it was some daytime talk show host or something. Can't remember what it was, but there were women talking about murdering their husbands because they claimed that they were abusive, and they murdered their husbands, or their husband was murdered in jail, and they were happy about it, and the audience was applauding, and the women were just like, you know, they were being like rooted on for the death of this vicious animal, you know. Of course, we don't know if the story is true or not, but that was disturbing. This was just last week. Like, this is current modern day TV. So this whole feminist theory is just infiltrating everywhere, and it was an American show. So it's just scary what's happening. Rather than see men and women as complements, like I believe most would, they see them as competitors and oppressor class. Yeah. We're here to complement each other. We have the physical parts, you know, we're built anatomically to complement each other and to help procreate, you know, and reproduce and keep our species alive and keep it from going extinct, just like every other species, like bees and birds and raccoons and horses and tigers. You know, I mean, if you have pets or animals, you know, they rape each other all the time. Do we send the cops? Do we arrest them? Do we separate them? No, we want them to get it on. We want them to reproduce, especially if we're, you know, if we have a beef farm, a cattle farm. We want those cows to reproduce, however they need to do it, right? We're not arresting them when you know, if it looks like, you know, Mama Jersey cow isn't getting it when she really doesn't want it, you know, or whatever. We're just so mean to each other. This human aspect of it. Moral chivalry. All right, I'll Google that. The more radical feminist, the more likely she is to be lesbian. Maybe, I don't know. I don't know what to say about that. Maybe, I don't know. I know lesbians, or I have known lesbians that I wouldn't necessarily consider radical feminists. So, 88% of the population, if forced to choose, would sacrifice a man to save a woman in a split decision. Well, if that's true, that's pretty disturbing. 88% of the population, if forced to choose, would sacrifice a man to save a woman. Yeah. I don't even know where you got that from and what research that's based on, but I don't know if I were to be put in that situation, what I would do. I couldn't even answer that question. I sure as hell wouldn't jump to that conclusion. I'll put it that way. Both men and women bias in favor of women on average. Well, yes, I think society has done that to us, though. Like, you know, if you go back to the hunter and gatherer days, you know, we rely on our men to bring us our meat, go do the difficult work, go climb the trees to get the honey. You know, like, we rely on them for those things, to help us feed our gaggles of children, right? To help build our homes. Like, back in those days and in those cultures that still do exist, I don't think that would even be an issue. I think people would just laugh at you or throw a spear at you if you ask them that question. Some of these women get radicalized in those battered women's shelter homes, which are often run by radical feminists. Yeah. Well, I believe that for sure. Now, I do know that there are cases where women's shelters are used to house young girls who are living in who are living at home, but they don't like the rules of the house, or they're not getting along with a step parent. Just overall, they're just not having a good adolescence at home, and they will end up in these women's shelters. Believe me, a lot of these women's shelters house that type of woman. Would it help if men left Canada and make it a female-only country? One would think so. I mean, you know, it's like they either want all the men to be in jail or they want, like, what is it that they're aiming for? One has to wonder, you know, it's like, like, are they looking for a statistic that every Canadian male has spent time in jail at one time or another? Like, is that what they're aiming for? Would it make them happy? Really? I know. No, I think that would just fuel their fire even more. You know, if every man was in jail or every man left the country, you know, let them go be toxic males somewhere else, not here. Screw them. That's probably what they would say. But then, you know, all the immigrants that come here because, well, hell, we need them because all of our good men are leaving the country. Or are jailed and can't leave the country and are miserable because of it. So we need a lot of immigrant population here to take on the jobs, work the farms and all that stuff. So they'll just attack them at some point. And it's just going to be a vicious cycle that's just going to keep rotating over the decades. Let's see what it looks like 20 years from now, who the feminists are attacking, once all the white men have been cycled through the jail. Comments not showing in the stream. Do you mean comments on below the video or in the chat? Let's see. Do you want... Chivalry is not dead when it comes to morality. Yeah, if you can send me the link. Where are you trying to send it to? We've evolved to protect women and children first because men are the reproductive expendable sex. Yeah, true. That's true. Yeah, I mean, we can only reproduce for, you know, a set period of maybe 20 years, 20 to 30 years if we're lucky, I guess. And men, though, they can keep reproducing, you know, their sperm is still sperming even when they're 100 years old. If you go back to 1900, 90% of the population of Canada lived in extreme poverty, less than $2 a day in today's money. So the idea was that men and women worked together to survive and raise kids. Yeah, well, that was very common. Men and women would work together in mom and pop shops, but we can't even do that anymore. We can't afford to run our own small business or mom and pop shop here. Especially now that the pop is under threat of being dragged away to jail. But even if that doesn't happen, taxed to death. Oh, do I have top chat on versus live chat? Let's let's see. Let's try and fix that. All right. There, I changed it to live chat. Oh, Sage Pub. Oh God. Oh, stuff that comes out of there is usually pretty sketchy. Thanks for pointing that out. Let's see. Copy. Okay, comments are never possible until the stream is finished. Yeah, I wasn't sure. I was wondering about that. Good to know. Switch dot. What? Hold on. Trying to get this page to load. For some reason, the page won't load. Switch dot. What do you mean switch dot? I have to give you a wrench. Do I do that by adding you as a moderator? Oh, replace dot with period. Hold on a second. Oh, I see it. Got it. Okay. All right. I see this chart. Hold on a second. All right. Here's the thing you sent me. Who would you throw off the bridge? 88% male bystander. Female bystander, 12%. I'm willing to push. Willing to... Oh, that reminds me. There was actually a show or some documentary or something I watched on Netflix, or I remember if it was on TV or something, where they actually had this. Oh, they actually, Mike. What was that? Okay, well, anyway, it was this show. I can't remember what it was called, but it was like this. It was this production where they actually did this test. Are you watching? Do you remember that show we watched where they were pretending, or not pretending, but they were challenged to who would get pushed off the edge of a building?
Oh yes, I remember the show, but I can't recall who it was.
Oh man, I can't remember what that show was. It was so good though. It was scary, but yeah, it was, the woman was most likely to push the dude off the top of a building, but none of the dudes could come close to even pushing the woman off the top of the building. It was like a psychological mind fuck where they had led them through these terrible scenarios to led them to believe that somebody was murdered, and this person, you know, one of the people in the group was the murderer, and they replayed these scenarios with different people each time, and each time the murderer was either a man or a woman, and they found that it was always the woman who was about to push the dude off the bridge, the top of the building. So yeah, I guess, yeah. I can't remember. I'm having a hard time, like, remembering what that was. If it was on Netflix, because we have Netflix. It was either on Netflix or it was something on TV. Yeah, all the women did it. Yeah, okay, so you know what I'm talking about. That was crazy. That was just crazy. I don't know if I were in that situation what I would do. I really don't know. The wrench is biological. I think you're talking about two different things. The link. Oh, okay. So here's the link that was posted. There you go, guys. So just out of curiosity, do I have only men on this stream tonight? If any women are lurking about, you know, feel free to just say hello. But if not, that's okay too. Actually, well, I'll know how many viewers anyway that I had, but not all of my viewers are subscribers or on YouTube, I'm sure. So anyway, all right, guys. Well, I covered everything that I wanted to cover tonight. So yeah, attack helicopter. So guys, if you have any requests or questions that you'd like answered in the next stream, or content or a specific case or anything like that that you want me to cover in a future stream, feel free to let me know, I guess in the comments on after the stream goes live. But right now what I'm doing, since I'm, you know, still just sort of testing out the whole live stream thing and the format of my show, I'm going to just keep these replayed, the archives of the live streams, available to subscribers, YouTube subscribers only, just because, I don't know, I'm still not completely comfortable with having, you know, my face out there and all that stuff, and I don't know if anybody is going to be abusing the content in any way or whatever. I'm just not totally comfortable with it yet. This is new for me. So Karen Strawn and Allison Tiemann have mentioned my work before. Oh, that's good to know. I was not aware of that. So cool. Thanks for letting me know. It's good to know. On the last one, there was no live chat replay. Oh, I don't know why that is. I have it set so that right after the stream, I end the stream, it immediately archives. So I guess that's why. Maybe the live chat replay only goes into effect if I keep it public. So you're in Ireland. Oh, okay. Cool. Oh. Well, thanks, Real Raven. Yeah, I did actually, you know what? Somebody from Honey Badger Radio did reach out to me. The gentleman who hosts the shows, I can't think of his name at the moment. He did reach out to me one time, actually sent me an email if I'd be interested in doing a show with them or coming on in an interview with them on a show. And I don't know, maybe I took too long to reply or something, I don't know, but I never heard back. I did reply eventually, but I never heard back, so I don't know. Brian, I think it was Brian. Yeah. Black Knight Fool, do you have a show? Oh, a shout out. Oh, okay. Yeah. Yeah. The Doge. Yeah, it was him. That's right. Oh, sure. Well, you know, maybe what I should do is see maybe if these people want to come on to my show as well. Maybe I can do some interviews. But hey, I'm willing, I guess, to go on their shows if they want to talk to me specifically about Canadian law or whatever. But, and just the terrible state our justice system is, and how much of a disadvantage our men are in these, you know. And I have to say, there is a small amount of women who are caught up in the same rigmarole as men are. I have read one overturned conviction of a woman who was also the subject of a historical sex assault complaint by somebody who was younger than her. She was a counselor or something like that. I can't remember exactly, or some sort of sports coach or something along those lines. A position of trust situation, and she was convicted just based on the story, yada yada yada. And then some proof came out. The appeal, she got it overturned on the appeal. There was some really strong arguments made in her defense, and she won her appeal. So it does happen the other way. Also, a lot of men also make accusations that aren't true, or are influenced by therapists and the recovered memory tactic. But the overwhelming majority of victims of this justice system, innocent accused who are victims of the justice system, are men. And the overwhelming portion of the complainants that are lying or have been brainwashed by a therapist or some counselor are women. So there you go. Yeah. I've had conversations with Diana, but offline. We chat offline every now and then. I don't know. Diana never does live streams, at least not publicly. Alicia Cleggs. That name sounds familiar. She's specialized in brainwashing. Oh, what, she does do brainwashing, or she researches the problems of brainwashing? Well, I'm gonna switch this back over here so I can. There we go. Yeah, if I could get one of them, that would be kind of neat. I wouldn't mind interviewing. Although I can't do these live streams for like hours on end like some people do, like for like 2-3 hours. Like that's too long for me. Yeah. Men are seen as more threatening. Physically, yes. I mean, do I look like a threat? No, right? I don't look threatening. Of course not. I'm so... right? But if you get a big, burly dude with, you know, scruffy face and thick eyebrows and, you know, thick neck, and he's just big, you know, that could be threatening. Yes, I could see that. But that doesn't make him a rapist or a murderer. It doesn't make him more likely to be any of those things. And just because the woman is sweet, pretty, demure, perhaps soft-spoken, short, small, and petite, it doesn't make her any less likely to hurt a man, or another woman for that matter. Ooh, yeah, she sounds like someone real Raven that I would love to chat with, actually. Alicia Cleggs, yeah, hook us up. That would be cool. I'd love to chat with her. Oh, her channel is closed. Ooh. Yeah, I'm mostly a shy person in general. I have terrible stage fright. I've gone to many conferences and debates, and, you know, I want to get up and speak as part of the audience, but I get, building up to it, I get so much stage fright. I get really, like, the nerves are just terrible. I don't know why I have such terrible stage fright in those situations. Speaking in front of people I don't know. If it's in front of people I do know, it's a totally different story. But when it's in front of people I don't know, it's stage fright. But I'll get over it. As the more I do this kind of thing, I suppose, and it goes well, and, you know. Toxic Threads. Is that her YouTube channel, Real Raven? I'm just writing that down. Alicia Cleggs. Okay. All right. Cool. Thanks. Alrighty, guys. Well, it's been a blast. Does anybody else have any other questions or anything? I'll shut it down. So yeah, so when I close this live stream down, I'm sorry if you don't have replay available to you, but just wait for the archived version to come. When you go to my YouTube channel, if you're a subscriber, you'll be able to see the playlist on my homepage. All of my archives, my live stream archives, are automatically going to be added to that playlist. Okay, so you'll always have access to it, and you'll be able to watch it from the start if you missed any of it. You just might have to wait a bit. I don't know if I'll do it tonight. If it'll be available tonight. It should be, I suppose. Unless there's anything I want to edit. But, nah, I'm not going to bother editing it. The first one needed some editing, but... Okay, yeah, Real Raven, I know you missed a bunch of it. So, it'll be available for you to reload and replay in the playlist. Just go to my homepage. Might take a couple of hours, though. Check it out tomorrow. Get some sleep, and then check it out in the morning. Alicia Lee. Oh, Twitter handle. Thanks, Theodore. Might already be following her for all I know. Hey, Fillerator. Thank you. Good to see you again. Thanks, Black Knight Fool. Alright. I won't edit this one, I promise. I feel nervous about my face just floating out there, you know, out in the Ethernet. But anyway. Alright, guys. It was fun. I'm going to shut her down now. Have a good night. Bye, Real Raven. Okay. Bye.